So this is our 9th week, and our topic for this week is drafting of subsidiary or delegated legislation. If you recall our discussion on miscellaneous provisions, one of the clauses is the power to make subsidiary legislation. We emphasized that during our discussion of miscellaneous provisions. So in legislative drafting, subsidiary legislation refers to rules, regulations, orders, and other instruments made under primary legislation. Primary legislation is the principal act, the one that the National Assembly made or the State House of Assembly made. That's the primary legislation, giving practical effect to its provisions and often focusing on implementation details, while primary legislation sets policies and principles. Some differences between primary legislation and subsidiary legislation are: 1, enacting formula. Enacting formula are different. For example, government area file when a democratically elected legislative council is different from when there is appointed caretaker of council. Now, in some states, the Supreme Judgment of financial autonomy for the local government areas. Governor wakes up one morning and appoints chairman of the local government who call different names. The last one in my state, they call themselves mayor. So you hear somebody like something like mayor of Aba North local government, of Aba South local government. So that chairman is not elected by the people, and his legislative council, they are not also elected by the people. So before they by that I mean, if election happens, their tenure is usually 2 years. So if election happens today, the chairman that the governor inherited, let me put it that way, he can wake up, maybe inherited a chairman from an opposition party or chairman in different local government party. Once he comes in, he decides to flush all the chairmen, leaving the councillors. Then he will now appoint his own people as chairman. Now, when that is the case, the enacting formula by that particular legislative council, which was not elected by the people, or the chairman that was not elected by the people, this thing is different. So in most cases, they call them administrators. But where the chairman is a product of democratic election, people went to polling and cast their votes, and eventually that particular individual emerged as the chairman. The enacting formula is also different. So, for example, where there is a local government chairman elected, that means they have a legislative assembly at the government level called legislative council. The enacting formula will be something like this: in exercise the power conferred by the local government law of, I'm using my state, Abia State, by the local government law of Abia State, the Umuahia North local legislative assembly enacts as follows. This is where the person charged as the local government is elected by the people. So the enacting clause, don't forget. Sorry about that. Someone says they are missing me. Please, if you cannot hear me, kindly indicate so that I repeat what I said. So the enacting formula, don't forget, shows the authority making the law. If it is a federal law enacted by the National Assembly, Federal Republic of Nigeria. If it's a state law enacted by the Lagos State House of Assembly, or the Lagos State House of Assembly enacts. Now we are saying if it is that there are two approaches to it. It's where the local government chairman is appointed as a sole administrator by the governor, or a second where the government chairman is elected by the people. So we are taking the one that is elected first. Where we have elected chairman, the enacting formula is something like this. In exercise of the power conferred on it by the local government laws of Abia State 2023. I'm citing it as an example. The Umuahia North Local Government Legislative Assembly enacts as follows. That is the enacting formula. But here it is the sole administrator that has been appointed by the governor. The enacting formula will be something like this. In exercise of the power conferred on me by the local government law of Abia State and 23. I see the person of the chairman. I mention his name. You mention his name, administrator of maybe Alta local government, Abia State, makes the following bylaws.
Ebenezer, your line is still cracking.
Oh,
Your line is cracking.
I'm almost screaming here.
Oscar, you are not giving Ebenezer that your this.
No, he has given me. He has given me.
They are missing some parts of it. So, for example, when you say the name and the title, the job title, they are missing some parts of it.
I said the sole administrator.
Okay.
Yes. Where is the sole administrator? The enacting formula is in exercise of the power conferred on me by the local government of Abia State, 1997. Sole administration makes the following bylaws. You see, the difference where is the sole administrator? The person of the sole administrator, his name is mentioned, one, and his office as sole administrator is mentioned. So that's the major difference. Whereas for where the people elected the governor, the chairman, he does not need to mention his name. He just says in exercise of the power conferred on it, because it is the local government that is making the law. In exercise of the power conferred on it by the local government laws of Abia State, the Umuahia North Local Government Legislative Assembly enacts as follows. The other one says in exercise of the power conferred on it by the local government laws of Abia State. I, one, Professor Ebenezer Ekwatu, two, sole administrator of Umuahia South local government, make the bylaws. So you note the difference. Now, that's the difference when it comes to subsidiary legislation. One of the major difference between subsidiary legislation and primary legislation is the enacting formula, which we just explained. Two, commencement dates. Now, for primary legislation, the commencement date as a general principle is the date the president assents to it, or the date the governor signs it into law. That is one. Two, it could be a future date. In that case, there might be a commission precedent. They might just put it, okay, you can make a law and say this law will take effect on 1st day of April. I cited the example of our new High Court rules, civil procedure, FPT 2025. That law was made in November, signed in November 2024, and was stated there that it will take effect from 1st March 25. So we are using the new court rule now, FCT. The date is futuristic or was futuristic. So for subsidiary legislation, it can only, the commencement date is the date it is gazetted. And that was the decision of the court in the case of Oro and others against University of Lagos. Igoro and others against University of Lagos, 1995. Now, in that
1985.
1985, please, sorry, not 1995, 1985. In that case, the then VC of Lagos had issues with some staff, and the Senate met on their own, passed a resolution to disengage these people, and they went to court. That disengagement was not gazetted. They went to court. The court ruled in their favor that they should be reinstated. And that was where this principle came from. That for a subsidiary legislation to take effect, because that's what commencement date does. Commencement date tells the date this law comes into force. So for a subsidiary legislation to acquire the force of law, the commencement date is the date it was gazetted. That subsidiary legislation has to be gazetted before it acquires the force of law. If it is not gazetted, there's no law as far as the courts are concerned. So it is of no moment. Then in the United Kingdom, some primary legislation contain Henry the Eighth clause, King Henry the Eighth clause. Now I will explain what it is, which allows subsidiary legislation to amend the primary legislation without need for amendment by the parliament. Let me explain. If we want to amend a law, a bill has to be generated, debated before the floor, an amendment, and the process of lawmaking, and passed into law, and it amends a particular old law. But here, some of their laws have Henry the Eighth clause. Now, King Henry the Eighth clause is a clause that empowers an agency that has power to make subsidiary legislation to also amend that the primary legislation without necessarily going to the parliament. How does it work? Maybe there is a development. The head of the agency can bring up an amendment through subsidiary legislation, and that amendment will stand, and that amendment becomes the new law and becomes enforceable, and that amendment actually amends the primary legislation. Now note, it is not in all cases. It is only in laws that have King Henry the Eighth clause. The King Henry the Eighth clause empowers an agency to use subsidiary legislation to amend a primary legislation without recourse to the parliament. Now, that is different from what we have here. What we have here is, if you want to amend a primary legislation, you initiate an amendment bill, either at the federal level, if it's a federal law, or a state house of assembly, if it's a state law. You initiate an amendment bill, and it goes through the regular process of amendments, and once it scales through, the bill stands amended. But here, you can use King Henry VIII clause, or you can rely on King Henry VIII clause and amend a primary legislation using subsidiary legislation. So what this does, one, is it helps the law to easily adapt to the dynamism of the society, to the changes of the society. So as the society is changing, those laws that have King Henry VIII clause is fast enough to catch up with the change through subsidiary legislation, because the subsidiary, the head of the agency, will just effect amendments to cure whatever crops up in the society that was not contemplated in the primary legislation. Then we have other examples here. Example is the United Kingdom's Immigration Act 1984. So we also have definition. Subsidiary legislation, also known as delegated legislation or second legislation, are laws made by bodies other than the legislature. We know that one of the primary cardinal duties of the legislature is lawmaking. So if you now have a law that was not made by the legislature, such a law is called subsidiary legislation. So that's what we are saying here. Now, it's not just any law that is made, because the body other than the legislature that is making the law must derive their power from somewhere. And that power is derived from a primary act made by the legislature. The legislature derives their own power to make law from the people through the constitution. The people vote them into office. There is a constitutional provision that have assigned them the responsibility of lawmaking. So when they make law, they now put a clause under the miscellaneous provision, power to make subsidiary legislation. The minister shall have power to make laws as he may deem fit in furtherance of the implementation or realization of this act. Full stop. That singular sentence has empowered a minister who is under executive to make laws. So that's what we are saying here. That subsidiary legislation, also known as delegated or secondary legislation, are laws made by bodies other than the legislature, but under authority granted by the legislature in a primary legislation. Again, what is the purpose of the primary legislation? What is the purpose of subsidiary legislation? That's another difference. Purpose. Primary legislation or statutes generally outline broad policy goals and principles, while subsidiary legislation fleshes out the details and specifies how those policies are to be implemented. Under section 20, under section 11 of the National Health Act 2014, there is a provision there called Basic Healthcare Provision Fund. Now, if you read the way it is provided for under the National Health Act, it may confuse you. But because the act also empowers the minister to make subsidiary legislation. In exercise of that power, they have made the Basic Healthcare Provision Fund guidelines, implementation guidelines. So that is like subsidiary legislation. This thing that Section 11 says, they broke it down how it will be implemented. So while the primary legislation outlines broad-based policy goals and principles, okay, there is now established a fund known as Basic Healthcare Provision Funds. The fund will do this, the fund will do this, the fund will do this, the fund will do this. That's the second primary legislation. Then the subsidiary legislation has now gone to break down step by step implementation policies on how the Section 11 will be realized. So the purpose, again, primary legislation sets out or outlines policy goals and principles, while subsidiary legislation fleshes out details and specifies how those policies are to be implemented. Examples of subsidiary legislation are: one, High Court civil procedure rules made pursuant to the High Court Act. The High Court Act establishes the High Court. So that is the primary legislation. Now, the day-to-day running of how the courts, the procedures before the courts, how cases will be presented, dates and timelines, computation of time, penalties, okay, how many days do you have to file a matter, limitation of action, how many to respond. If you are served a motion, how many days do you have to respond to that motion? Okay, what documents should accompany your process? If you're filing and originating someone, what documents should accompany? All those minute details, they are not contained in the High Court Act. But the Chief Judge of the state is empowered by the High Court Act to now make rules that will guide the day-to-day running of the courts. So High Court civil procedure rules made pursuant to High Court Act. Two, practice directions on virtual court hearing during COVID-19 made by the Chief Justice of Nigeria and Chief Judge of Federal High Court. Now, during COVID, nobody saw COVID coming. They said lockdown, sit at home. But there must be a way to administer justice even in the face of the pandemic. So the best approach was to make a COVID regulation, practice direction on virtual hearing. Court judge will sit in his house or in the court alone. You counsel, you sit in your chambers. The other party is sitting in his chambers or in his house, and the hearing goes on through the internet. Now, in the new rule, it was not expressly provided in the old rule. It came as a practice direction. In the new rules, it is expressly provided now because we have conquered the challenge of COVID, and we say in case any pandemic that will require people to stay at home tomorrow, let us include virtual hearing now. But beyond the pandemic, in case somebody is out of jurisdiction, to reduce the cost of just coming to court to testify. Imagine somebody is in Lagos, a matter is going on in Abuja. The flight ticket from Lagos to Abuja now is more than 150,000 naira. So, assuming the person is not based in Abuja, your flight ticket to and fro, hotel accommodation, intra-city commuting cost, and all that. So, to save the risk and the cost, we now have virtual hearing. So you can actually apply, my lord, my client is out of jurisdiction. You furnish the court with your facts via your affidavit, why the application should be heard, or why your case should be heard virtually. And the other party, wherever he is, he can stay there and give evidence. So you see that through this lawmaking process, there is an improvement to tackle whatever problem that may arise tomorrow that will make people not to come to court physically. So it is no longer an excuse. My lord, we are sorry, the client missed his flight. That excuse has been banished forever. Because you can now, even while at the airport, if you have missed your flight, while at the airport, you do virtual hearing there. If you had applied earlier. Next, executive order must be made by the president or governor. The governor can make executive order. The president too can make executive order. Now, the president is the executive, not legislature. The governor is the executive, not legislature. But any law they make through executive order is part of subsidiary legislation. Other common forms of subsidiary legislation include regulations, rules, orders, proclamation, and notices. So it must not be express legislation, even within the ministry. All those internal regulations that come. During COVID, relying on the Quarantine Act of 1926, we got COVID regulation of 2000. That's a subsidiary legislation. Rules of court, subsidiary legislation. Some orders, subsidiary legislation. Proclamations, subsidiary legislation. Notices, they are subsidiary. As to procedure, they are subsidiary legislation. Then, flexibility. Subsidiary legislation is often more flexible and easier to amend than primary legislation, allowing for quicker adjustments to policy implementation. We have overflowed this issue. The process of making bill, first reading, second reading, committee stage, public hearing, back and forth, engrossment, a third reading, and all that, you notice that it is a cumbersome process. But subsidiary legislation, very flexible and quick. It does not go through that process. Relationship to primary legislation. Subsidiary legislation must be consistent with and operate within the framework established by the primary legislation. So you cannot say that you are using subsidiary legislation and you veer off totally out of what was stated in the primary legislation. Whatever subsidiary legislation you are coming up with must be to further the implementation of what is already contained or stated in the primary legislation. So that nexus, there must be that link, there must be that relationship between the primary legislation and subsidiary legislation. Where your subsidiary legislation makes a law outside the primary legislation, the court will hold that such is ultra vires. You are exercising a power that is beyond you. You are exercising a power you do not have ab initio. So it will be of no moment. Then, drafting considerations. When drafting primary subsidiary legislation, drafters must ensure it is clear, precise, and consistent with the primary legislation, and also consider how it interacts with other relevant laws. The primary subsidiary legislation is not a standalone law. It does not have a foundation of its own. It is attached to or rather, it derives its life from the primary legislation. So you cannot make a law, draft a primary legislation that is radically different from the primary legislation. So your primary subsidiary legislation must be consistent with the primary legislation and with the purpose of achieving implementation of the primary legislation. Importance of planning. When planning the draft of subsidiary legislation, it is important to consider the enabling power, the structure of the act, and how the order dovetails with it. So, even if the power has been granted you to make subsidiary legislation, you as a drafter, you must go and recheck that document, the source of that power, because you are being briefed. The person can come and say, yes, I am the head of this. Under our Establishment Act, we have power to make so, 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 and so law. You are the expert here. The person might just be acting on assumption. The person might be acting based on what their lawyers in the office have told them. But the person could have expanded their power without even knowing. But you as a drafter, you must first of all consider the enabling law where he's deriving his power. 1. 2, the structure of that act that established them. 3, how will I marry this act with the subsidiary legislation I am making? How will this subsidiary legislation I'm making, how will it aid the implementation and realization of the purpose of this act? So, apart from that, if you do any other thing to the contrary, the law will hold that you are out of order or traverse. So at this moment, we would like to hear from our Lesotho participants how their primary legislation functions, how their subsidiary legislation functions. What is the commencement date of subsidiary legislation in Lesotho? What is the commencement date? Can anybody tell us? We said our own here, the commencement date is when it is gazetted. If it is not gazetted, it has no force of law. So, can we have participants from Lesotho to tell us what obtains there? Any participants? I am going to call names. Teboho, please, I've not heard your voice in a long while, for almost 2 weeks now. So can you tell us what obtains in Lesotho in respect of subsidiary legislation?
Hello, Ebenezer.
Yes.
Yes, I think it will be upon gazettement as well, this side, because on our side, subsidiary legislations have to be submitted to the parliament before it can be effected into law.
Okay.
So the parliament has got 15 days either to accept or reject that submission.
Okay.
Yes. So once
Where the parliament rejects it, what happens? Let's assume a subsidiary legislation is laid before the parliament. After 15 days, the parliament does not approve it. What happens?
It means it won't be, I think.
Okay,
Hence,
is
it
it that
cannot
it is
be
taken
regarded as
back?
law.
Is it that it is taken back, amended to suit what the parliament wants?
As
or
raised, yes.
that is the end of the road for that particular bill or law.
I believe it will be taken back to address whatever Parliament has raised as issues before it can be laid into Parliament again, before Parliament again.
Okay. Thank you very much. Thank you for that contribution. So, any questions so far on what we have done? Subsidiary legislation. Any question? Any question on what we have done? Yes, please, Mr. Vincent. Mr. Vincent, you may proceed. Ask your
Okay,
question.
thank you, sir. I have noticed that in Nigeria, some authorities that have been given powers to make subsidiary legislation, for example, rules of court, they still rely on the rules of court, the subsidiary legislation they give, to make further instruments like practice directions, like guidelines. So I want to know how proper is this practice? For example, the chief judge of the FCT makes the rules of court pursuant to the High Court Act, which is made by the primary legislation made by the Parliament. Now the CJ now relies on the rules of court he made by himself to issue a practice direction on a particular subject. For example, in the FCT we have practice direction on enforcement, practice direction on several aspects of the rules. So I want to know, is this a proper practice in legislative practice drafting?
Yes. You know why? The authority he derived from the High Court Act was for the purpose of making laws for the smooth running of our court system. Do you understand it? Now, the chief judge now makes High Court rules. In the High Court rules, there is a provision to make further practice direction as the need may arise. And now they have made practice direction for enforcement. What that has done is certainty has been established. Prior to this time, you can enforce anyhow. By that, I mean not that you can just wake up and do what you like, no. Not that there was no order, no. But by that, I mean it was not documented. You can easily be cheated. You can easily be deceived. You can easily be misled as a lawyer, because it is what the enforcement unit tells you that you go home with. But now, even before visiting the enforcement unit, you can pick up the practice direction, sit in your office, read through it. There is certainty now as to how enforcement should be done. And it is still part of our judicial system. So any derogation from that laid down procedure of enforcement, you as a lawyer can take it up. This is my personal opinion, though. Your thinking is that maybe he should not confer on himself. I think that's your argument.
Exactly.
That he should not confer on himself the right, the power, right, from the High Court rules. But I feel that once the High Court Act has given him power to make rules, it is just nomenclature now. Check if you saw the listing we made of what subsidiary legislations are. We said rules, 1, regulation, order, declaration, notices. Do you get? And
Yes.
even directives. So they are all subsidiary legislation. Both the rule of course, and the practice directive are all subsidiary legislation. That's my thinking. Prof, I don't know if I'm correct. So, thank you, sir. Any other question, please, on this? But I like that your question, Mr. Vincent. It's an interesting one. So, any further questions here, please? Any other question? Uren, you came to class today. Welcome. I've not welcomed you officially. Who else am I just seeing? Mr. Justus, good afternoon. Long time. Welcome.
Yeah, good afternoon, sir. So sorry, I've not really been around for some time now.
Welcome, sir.
Thank you so much, sir.
Madam Joyce, good afternoon. Welcome to class. Masufa, good afternoon. Welcome. Okay, in the absence of any other question, we shall be coming to the end of today's class. Tomorrow is Friday. Get ready for your assignments. We just have 3 more weeks to go. Who have made entitled to an award of certificates upon fulfillment of the conditions, particularly your processing fees. So that is that. So in the absence of any other question, we have come to the end of today's lecture. See you all tomorrow. Thank you very much.
Thank you very much, sir.
Thank you, sir.
Madam Hannah, good afternoon. Welcome. Glad to have you on the call.
Good afternoon, sir. Good afternoon, Prof. Good
Okay.
afternoon.
Madam Hannah, we will need a quick feedback from you. Others have done same. What we are doing here, has it in any way been of benefit to you? Have you learned at least one thing from here that you have added to your knowledge of legislative drafting? Has it in any way been of help to you, or are we wasting your time? Let us know, please.
Okay, thank you very much, sir. Once again, good afternoon, Prof. Good afternoon, everyone. I must really say, well, the course has really impacted me because previously I just had a very scanty knowledge of legislative drafting. And that was when there was a time the NBA branch organized, and it was Prof that actually, facilitated the seminar. It was our facilitator. That was years ago. So I was able to pick a few things, though it was the time for the webinar, the seminar was very short. So when I got hold of this legislative drafting course full time, I don't know if you remember last year that I joined, but for some reasons I dropped out of the course, but I decided to join back again. So, I mean, it has impacted me a lot. Moving from where I was before, I think I know better now. Even before I joined this call, there was this senior colleague I was talking to, and I said I needed to be in class. So he said, what am I doing? I said legislative drafting. And he was trying to say, oh, is it not the same thing like what we did in law school, legal? Then I started explaining and the parts of a bill and what have you. So he said, oh, he doesn't know that legislative drafting is much deeper than what we used to know. So it has impacted me. And presently I'm doing my LLM, and it's also like a course, in my LLM. So not a mandatory course, but an elective course, which I also opted for. So this training, I see that it is helping me a lot because we've done some assignments, and honestly, I have improved. And
Wow, that's good though. Come and pay money. Which school are you doing your LLM?
let me just wrap it up. It has helped me a lot. Thank you for all you do, Prof. I really do appreciate it. Bingham University, Nasarawa.
Which one are you doing? Okay,
Hello?
Nasarawa.
Yes,
said, which
Bingham
institution?
University. Bingham University, Nasarawa State.
Wow, that's a good one.
Yes.
Huge congratulations. Huge
Thank you, Prof.
congratulations. Very big
Yes.
congratulations.
I really appreciate Prof, and I appreciate you as well. You always take out time to explain over and again. I appreciate everyone on the call. Thank you, sir. Thank you, Prof.
Thank you. Thank
Who
you.
is the
So,
who
Mr.
is the
Vincent,
dean
you have
of
the floor
Bingham
now.
now? Who is the dean?
Professor, I think there's this professor, is her name Natasha, or I can't really remember her name. It's just a
Another Natasha.
Magdalene. Sorry, Professor Magdalene.
Okay.
We have one. One is enough. Why should you go and bring another?
Okay, Professor Magdalene, not Natasha. So sorry about that.
Only one Natasha. Oh, two now. One from Two-Face, one from Senate. They want to
Yes,
put.
and the third one from Big Brother.
Ah,
Thank you, sir.
well done. That Magdalene, was she not the? She was from Taraba State University, right?
I'm not really sure, but someone told me she also lectured some time ago at Benue State University, Faculty of Law. She was
Okay, okay.
actually their dean at some point. So, but I'm not really.
Okay.
Okay. Welcome, everyone. Thank you. Mr. Vincent, quickly do the introduction so that we go into today's lecture, please.
Good afternoon, Prof. Good afternoon, everyone.
Good afternoon.
Thank you, sir. My name is Vincent Adodo. I practice law in the Federal Capital Territory, Federal Republic of Nigeria. And I have a master's degree in Information and Communication Technology Law from Nasarawa State University, Kefi. So I got to know of this group through Prof. Remotely through the Law Center, a platform created by Mr. Sylvester Idemezi of the Nigerian Law School. So it was from there that I do follow Dr. Jaja's write-ups, articles, and all the rest. So I took interest in the ALDRAP, and I linked up with him. And it was from there that I got to know that a training like this exists. Thank you.
Awesome. You are most welcome, and we look forward to having more of you. The training runs Monday to Friday by 1 p.m. Lesotho time, which is our 12 p.m. It's just 1 hour. 12 noon Nigerian time to 1 p.m. here. And that time, because we have participants from the Kingdom of Lesotho, so it is their own 1 p.m. We have gone really, really far. The training is actually 12 weeks training, and this should be our week 8 or 9 of the training. So you can see we have gone far, but you have no cause to fear, because when we exhaust the timetable, we start all over again. So the training continues, except where there are public holidays or any other foreseen circumstance that makes the class not to hold. But barring any of such, the class holds Monday to Friday, 12 to 1 p.m.
Thank you.
Thank you. So